Lords, good morning. Two very small points of documentary sourcing, if I may, to start with. Your Lordships had the additional bundle we handed up yesterday, I think, and I can't remember which of your Lordships asked to see the deed of release, or the deeds of release, which we included. I think it may have been Lord Justice Snowden. In tab 4, let me just introduce them to you very quickly. I'm not going to make any comments about them. The first is, as you can see, type dated 2016 and hand dated 2017. And if you go to page internal 6 of that clip, you'll see that it's signed by Mr. Whitworth. Now, what we have got here is the two executed counterparts. So if your Lordship, we'll go back to page 3 internally. That, I think, was not there at the time, back in December. So when it was signed in draft, it was simply signed as a draft document with nothing on it. The second one that you have, starting at page 7, is in identical form to the first, other than we can now see that it's type dated June 17, not hand dated June 17. And the relevant information on it is typed. And on the right hand, if you go back to the page 12, internal page 6, but the last page of the clip, you'll see that this is the other side's counterparty signature. So your Lordship asked to see that. There it is. I don't think anything turns on it, but I didn't want to leave it unsourced if you wanted to know it's there. The second documentary source you asked me yesterday, Lord Justice Snowden, about the NAV requirement source, and unfortunately I can't provide that to you in one document, but if you find a reference to it, please, at page 83 of the supplemental bundle. That's our tab 4 of the supplemental bundle. There may be other references to it, but this will do for the purposes of introducing it. It's the top paragraph on page 83. This is in a section dealing with the role of the administrator, which is Maples. And that paragraph you've seen refers to the net asset value and their obligation to undertake that. Net asset value is then defined on page 144 of the same bundle. 114, forgive me, 114 of that bundle. And here you'll see why I can't provide it to you in one document, because it says it's calculated in accordance with the articles. And the relevant article is 8.1. I have full copies of that here. I'll hand those in at some suitable stage, but unless anything turns on it, if your Lordship wants to see it, it is there.
But I thought the point that was being put was that before there was any payment to FIML, there had to be a NAV calculation as a matter of restriction in the offering memorandum.
The offering memorandum requires it in accordance with the articles.
Well, yes, but it doesn't. Sorry, am I missing something? The top paragraph of page 83 just says that the administrator is the person to determine the net asset value. It doesn't. Where does it say there can't be a payment to the investment manager, FIML, under the investment management agreement, unless a NAV has been performed by the administrator? I thought that was the point that was being made, that there was a restriction evident from the offering memorandum preventing a payment being made. Sorry,
Lord,
I'll repeat myself.
Lord, may I come back to you on that? It's difficult to track it down. It was dealt with at the trial. It's referred to in the judgment. I was just simply trying to find the documentary source for it. And if you want more, I will certainly try and find it. But I can't go further than this at the moment.
I suspect we're going to get onto this during the course of the morning.
We will.
Somebody behind you may be able to.
If we can get a little bit further with it, we will. But as I say, I was conscious your Lordship asked for it, so I have no doubt that we have to produce it if we possibly can. So I'm now going to take you to continue where I was yesterday, and I'm going to start the story, if I may, in December 2016. I told you yesterday that the story started in 2016. I'm now going to make that good. Would you turn up, please, the judgment at paragraph 177, page 151. I'm not going to source this through documents because it's not challenged. Paragraph 177. What you will see there is in December 16, Mr. Nuseibeh had instructed Churchill Salmon, solicitors acting for the fund, that a termination or restructuring fee to be paid by Reading upon redemption was to be paid to another Floreat entity, quote unquote, rather than the fund. The amount of the fee contemplated at that stage was £600,000. Now, I pause to mention this is going to be a theme of what I'm going to say about this right up until the 19th of June, that none of this activity was or had been the subject of discussion with or approval by Mutazatabi. Paragraph 178, the fund invites the following findings. That Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh decided in December 16 to divert any termination fee paid by Reading to FIR without seeking the fund's permission to do so. Secondly, 721, the three of them did not inform Mr. Whitworth or the fund's board that they intended to act otherwise than in accordance with the facility in respect of how they calculated the termination fee payable or diverting the sum away from the fund. 179, His Lordship was able to make these findings on the evidence he had heard, as with one qualification, say that I'm not satisfied by this point. The decision was to use FIR as the destination for the whole termination fee. I address that later in the judgment. And then he goes on 180 about the deed of release, which I...
Well, sorry, what he says is, I address later in this judgment the circumstances behind the facts accepted in these findings. So, where later in the judgment does he
Lord,
do that?
I'm going to take you, during the course of the morning, I'll be taking you through everything which I think is relevant to the conclusions that he drew. So I'd like, if I may, just to keep it in order for the moment. I would respectfully submit to your lordships that a finding by him that they had decided then to divert the money, but they hadn't decided on the which company, is in effect as close to a finding of dishonesty as you could hope to get, confined with the fact that it had not been discussed with Tazutabi or the fund. Then the position moves to April 2017. So could we pick this up, please, to start with, paragraph 235 of the judgment. So this will give you a reference, which I don't think you've seen yet, to part of some chat, Bloomberg chat. I'll just invite you to read through to yourselves for a moment.
Well, you're jumping from December 2016 to April 2017.
That
passes over what's a period which was covered by an extensive lot of allegations in the particulars of claim, which the judge rejected. But didn't he, about alleged doctoring of emails and all that kind of stuff?
Yes.
Right, but I mean that was part of the case as originally pleaded, which obviously was collapsed in light of the judge's findings.
Some of those points did not succeed on the facts, and I entirely agree. I don't seek to say anything about that.
Okay.
So let me explain then what I am, what my purpose is this morning. My purpose is to introduce this court to material in the judgment and a small selection of documents which sits behind it, but not with the large selection of documents one might have imagined were this a full-scale appeal on fact, in order to provide support for the vindication of the judge's conclusions. That is my sole purpose. I am not revisiting everything that was canvassed at the trial. I don't believe that to be the subject of this appeal.
And 235 that you're about to take us to, is that right?
I was just going to ask, I've moved from December 16 to April 17. I just wanted you to read through and note what was happening recorded by the judge at 235.
In relation to the termination fee.
In relation to the termination fee. Could we then please look at what we said in our closing submissions? So could we then go to supplementary bundle 2, in my tabs anyway, 498. So that is going to be tab 30, which I hope is in your supplementary 2. And I'm just going to invite you to read, if you would, the parts of the Bloomberg chat which is included and set out in somewhat more extensively than the judge picked out at our paragraphs 138 and 140. And if your lordships have got that far, can I then ask you to go back to the judgment, please, and take up paragraphs 212, 213 on pages 155 and 156. Page 155, we've got the start of paragraph 212, which says the fund seeks this finding, and the finding sought is on the 10th of April 2017. Mr. Nuseibeh and Mr. Diallo discussed ensuring that the three individual defendants received at least half the termination fee to be paid by Reading. I'm able to make this finding 7.25, save for the words at least. The discussion is dealt with in more detail below at page 235 and following, from which it will be clear that the finding captures only part of a more complex exchange. So I don't think anything turns on the qualification. But those are the findings that the judge made in relation to April 2017. I'm now going to move, please, if I may, to the following month, which is May of 2017. Could I ask you, please, to have available supplemental bundle 1 and go to page 144. Page 144, tab, I'm sorry, I didn't give you a tab number, it's 8, tab 8. This is an email instruction from Mr. Nuseibeh to Burgess Salmon, and you'll see in the middle of the email there's a reference to some numbers in bold. Please ignore that and look at just what's underneath it for the moment. Please note, as discussed previously, the termination fee and the loan notional due will be paid to two separate bank accounts, so please let me know when you need them. so the amounts are directed accordingly. Now, the point I wish to make at that stage is that the defendants obviously had it in mind that those two payments went in different destinations. This had not been the subject of discussion with, or agreement by, or approval from Tazatabi or anyone else at the fund. And I wish to move, please, if I may, to look at the draft cancellation notices which you've got in the file that we looked at this morning. Now, there are two cancellation notices. The first was prepared on the 1st of June 2017. That's the first one that appears in your bundle. I'm so sorry.
Sorry, which bundle are we in now?
So this is tab 2. I'm sorry, I didn't give you a tab number. It's tab 2 of the additional file. So the file we looked at this morning with the deeds of release in, it's that one. So let's just peek, as I'd spoken whilst you were still searching for the subject. The first of these documents with the number at the footing 124/1, that was prepared by Burgess Salmon and provided on the 1st of June and provided to Mr. Nuseibeh on the 2nd of June. There are a number of features of this. I think it was also copied to Mr. Diallo. The features are, at the top, that it was created by Burgess Salmon to be put onto fund note paper. Secondly, we can see the date, just there's no doubt about that, 2nd of June. The first main paragraph says, we write in our capacity as note holder in connection with the above-mentioned note issuance. Numbered paragraph 5 says, pursuant to clause 8.4 of the note issuance facility deed, a termination fee is immediately due and payable by the issuer to the note holder. And then at the foot of the page, we can see them accepting what they've been told by Mr. Nuseibeh on the 30th of May, that there should be 2 destination accounts, but they weren't filled in because no one had told them what to put in them. Now, at that stage, could we please take up supplementary bundle? So can you leave that to one side?
Sorry, can I just...
Of course, Lord. If I'm going too quickly, I do apologise.
Well, this document, the email you took us to at page 144 is the last email in a chain, which started a couple of weeks earlier.
It did.
When Burgess Salmon confirmed, following a conversation, it would appear, between Mr. Nuseibeh and Victoria Alsop of Burgess Salmon, that they were already holding a DS1 and a deed, which I think is, I don't know what DS1 is, and anyway, a deed of release signed by David Whitworth on behalf of the fund, which were attached. Is what was attached the document which you took us to, the deed of release you took us to this morning at tab 4?
As far as I recall, signed in blank.
Signed in blank.
In blank. So,
Right.
so it wasn't the one we've got. Is the one which was used as a counterparty copy in June. So
Okay. So, and Walker Morris have already agreed to the funds flow and redemption mechanics detailed in the attached form of undertaking, which is what?
As you're all reading from the top of page 146.
I am, yeah.
Yeah. I don't think, I can't recall seeing that document at any stage, but that just may be, I can't remember back 2 years. It's certainly not in the appeal bundle.
Right.
And I don't think, I honestly don't believe there's anything there which is relevant to the points that I'm making.
Okay.
Destination.
But then at 144, in the email that you drew our attention to, it says underneath the figures of assuming the final redemption of Friday day of 2nd of June, please note, as discussed previously, the termination fee and the loan notional due will be paid to 2 separate bank accounts. What was the evidence about that previous discussion?
I don't think it was more than that it will, just a discussion that it will go to 2 separate bank accounts. I don't think it was more than that. I don't recall, if your Lordship wants it, we'll try and hook it out, but I don't recall there being any significance in that conversation other than that it led to what we see in the first draft of the cancellation notice. I'm told there's, I can't recall it, but I'm told there's a reference in J224 that we might go to. Judgment 224. Yes, I think we certainly have seen the instruction 224, maybe part of that. Well, that's all that's recorded in the judgment. I genuinely do not recall any other document underlining this, which is relevant to the points that I'm exploring. So I may be wrong, but I don't recall.
But is this what you're driving at? That it was dishonest to instruct Burgess Salmon, or to discuss with Burgess Salmon, that instead of the money being paid to a bank account in the name of the fund, that the monies should be paid into 2 separate bank accounts?
Yes, this was part of, as the judge found, a plan which they had decided upon in December, which was to ensure that the termination fee, or part of it, was diverted. And you will have seen, because you've seen the judge's reference to it, that he's very clear about what they determined to do in December. And what we're now going to see, we've seen his reference to that it was to go to one of their companies, but they hadn't decided which. And now we're going to see how they instructed Burgess Salmon to alter the cancellation notice.
Okay. And then at some point you'll explain how it is that in fact the monies were actually paid into Burgess Salmon's client account.
They were paid by Reading into Burgess Salmon's client account on completion.
Yes.
Yes.
As opposed to being paid into 2 separate other bank accounts.
Lord, that is correct. Sorry. It's simply because Reading did not comply with the cancellation notice. I'd call that evidence being given. So that's the cancellation notice which was sent. Reading just paid it into Burgess Salmon's account.
Okay.
Lord, in answer to your first question, would I be able to say to you that one email taken out of context was evidence of dishonesty? The answer is plainly no. What I'm embarked on doing is to give your lordships what the judge had at a 2-week trial, but I can only do that in short order. We can't go through 2 weeks of evidence in this appeal.
Although in these documents, at any rate so far, all of the termination fee was to be paid to a single company, the judge doesn't find, does he, that the defendants intended to keep it all for themselves?
Correct.
So, from their point of view, it was convenient that they get their hands on it, but always with the intention of giving half to Mutaz or his company. So, is that right?
Lord, I think that is a fair reflection of the judgment, taken as a whole.
Yes. So although the fact there's one company who gets it looks potentially sinister, as if they're trying to keep all of it, although there is a 100% ha mention in one of the
Indeed.
chats, the judge was not persuaded by that.
He was not. And also, just to remind you, and I'm going to come on to this as a piece of balancing evidence, if you like, which you've seen before, the reference from Mr. Nuseibeh to saying that this was a placeholder. But I'm going to, that we will come to in the additional bundle. Actually, it's there. I think you've seen it already, but I would bring you back to that because it's, as I say, perfectly right that it goes into this balance. So, if we then look, please, could we now go to page 148 of the supplemental bundle. Now, there is a section in the judgment on this which you will have seen. On the section in the judgment, this is the found an idea email. So this you're looking at 144 tab 148 tab 11 tab 9. It's dated the 2nd of June 2017. It's Mr. Diallo to Mr. Nuseibeh. I found an idea on why FIR exit fees are like upfront fees. These are fees and were never to be shared with FMB, and due to conflict, never to be run via the fund. So we use the two Cayman entities. Lord, that is the idea of trying to say that the termination fee due to the fund can be said to be similar to the upfront fees, and the upfront fees were fees which, pursuant to the conflict exclusion in the IMA, permitted introductory fees to be paid to FCM or their nominees pursuant to agreements to that effect with third parties, not the fund. In other words, agreements with the fund's counterparties. And you can see Mr. Nuseibeh responding to that at page 149, saying that he thinks that works. Now then can we go to the judgment, please, and see how the judge dealt with this aspect of it. So can we go to page 3, paragraph 361. And it'll be swifter if I ask your lordships to read it yourselves. Could you please read paragraph 361 and 362 up to the end of the first answer on the next page, page 188. we're still on the 2nd of June, so we've had the found an idea, we've had the receipt of the first cancellation notice, we've had the found an idea, and we now need to move to the second cancellation notice, which you will find at tab 3.
Sorry, the document that's being cross-examined about in paragraph 362, can you just give me the reference to the document?
That is...
It's not the document you just asked us to look at, is it?
No, I don't think it is. Can I come back to you on that? I was about to say it was the found an idea email. Looking at it, I'm not sure it is.
It isn't.
I'll come back to that. So so the history is we start with the Burgess Salmon draft 1. We then have a found an idea email, and we then need to go to Burgess Salmon draft 2. Now, what we know from Burgess Salmon draft 2 is that this was redrafted on the instructions of Mr. Nuseibeh. And we'll find this at tab 3. So it's now on Floreat Capital Markets headed note paper. It's still dated the 2nd of June, which was a Friday, I think. The first paragraph has been redrafted. May I assist, my lord? Are you searching for a document? May I help?
I've seen that cross-examination in the transcript somewhere, and I was looking for it. Sorry.
Oh, I see. I understand the inquiry on. We will track it down and put it in its context for you. So,
was it on the 2nd of June? I mean, you've been taking us... I understood you were trying to explain to us what you say happened on the 2nd of June.
My recollection is yes. If I'm wrong about that, we'll correct it. But my recollection is that I was talking about events of that day.
Right.
So we're still on tab 3.
Yeah, okay.
So, my lord, as you were searching for the document, may I repeat what I'm saying? It's now on Floreat Capital Markets headed note paper.
Yeah.
It's dated the 2nd of June, so the same date, which I think was a Friday. The first paragraph is now changed. We act in our capacity as investment advisor to the note holder. You can note then that paragraph 5 has changed, because paragraph 5 required, or recited, if you like, that under clause 8.4, the termination fee was due and payable by the issuer to the note holder, and this now stops at the word payable, and by the issuer to the note holder has been removed, and payment was demanded on Monday the 5th, as we know, Monday 5th of June. Now then, what was blank at the foot of the draft that we saw in tab 2 is now filled in, and what we have is the fund for the outstanding amount, and as we know, IRL, as we're all calling it, for the termination fee.
And the amounts have changed?
Yes, it's $70,000 less. On that?
Yes. I can't recall the explanation for that.
And the amount outstanding under the note appears to have increased.
Yes. Well, I do recall discussion at the trial about how the termination fee was being calculated, whether there was any rational basis for it, so on and so forth. I can't now remember whether that was relevant to this issue.
Or what they appear to have done actually is taken the face value of the outstanding, what was previously said to be the face value of the outstanding note. That's the number that's been put into 4.
Well, that may well be. So that then is the.
And those are the numbers. Those are the numbers that appear in the manuscript on the deed of release.
They are.
With an initial BS by the side of it.
Yes, and that, Lord, if I may say so, explains why, when I said to you that this document was originally signed in complete blank, must be right, because we don't get those numbers until we get to the 2nd of June 2017, which is why it was then filled in and used as an execution copy. So, Lord, can I now go to the judgment to see what the trial judge said about this? So we'll get that, please, in his paragraph 228 and following. So, Mr. Nuseibeh, it reads, instructed Burgess Salmon to amend the cancellation notice, so it was in the name of FCM. On the 2nd of June 2017, Burgess sent Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh the amended cancellation notice. That's the one we've just seen. In line with Mr. Nuseibeh's instructions, it was in the name of FCM London. The cancellation notice was then signed by Mr. Diallo on behalf of FCM London, acting in its capacity as investment advisor, and sent to Reading, including the request that a termination fee of 2.2 million be paid to FIR. The fund asks the court to make these findings. 728, the individual defendants instructed Burgess Salmon to call in the loan on the 30th of May, pursuant to the fund's contractual rights under the facility, without first seeking the permission of Mr. Otaby, the fund, or FIML to do so, and without then informing the fund's board that they had done so. And there's references to that in the judgment elsewhere. Factual finding 729, the individual defendants instructed Burgess Salmon to amend the cancellation notice such that it was signed by Mr. Diallo on behalf of FCM and the fund rather than representative of the fund. It no longer stated in clause 5 that the termination fee paid by Reading was due and payable to the fund, and it included bank details for payment to the facility direct to FIR. Factual finding 730, the individual defendants instructed Burgess Salmon to issue the cancellation notice to Reading, which demanded a termination fee payable to FIR without seeking the permission of Mr. Otaby, the fund, or FIML to do so. Paragraphs 231 save that the instructions for Burgess Salmon from Mr. Nuseibeh, and save that Mr. Otaby had already given the capital I instructions. That wasn't pausing there, those instructions did not include this aspect of it. That included the instruction to get the loan called in and negotiate the terms. That's all. So I'm subject to that. I am able to make findings in those 3 paragraphs as sought. The funds.
But to say that is quite a big qualification, isn't it? Because what he means by that is that FCM London were doing what they'd been told to do, which is get the loan in,
well,
and not worry about the termination fee. This part of this goes to the missing termination fee point, which the judge rejects.
Yes, that is, if I may say so, that is referring to the breadth of the capital I instructions, which the judge was perfectly comfortable in saying embraced the possibility that they could negotiate that fee on a commercial basis.
I mean, what are we? It's all very interesting to go through this, but what are we actually getting from it?
Well,
bearing in mind the judge's ultimate finding that Mutaz gave his informed consent, albeit subject to the points about his authority.
What we gain from it is the point that I was making yesterday, and I'm hoping to make that good. If I fail to make it good, there will be certain consequences to that failure.
No, as long as we know, as it were,
where it's going,
what we're looking at, all this to get from it.
It was to make good the proposition that I put to your lordships yesterday, But this wasn't a simple question put to Mutaz Tabi on the 19th, and they both agreed on it. This was, in fact, what happened on the 19th, the fruit of a plan which had started, as the judge found, in December 2016 to secure the diversion of the termination fee from the fund so that they may benefit from it, and as we will see with the judge's languages, because they were not prepared to take the risk that if it went to the fund, there may be some delay in them receiving all or part of it, or all or part of what they considered to be their share of it. And your lordships will remember, I hope, that I was submitting yesterday that what we cannot do, and I urge the court not to do, is to see as distinct episodes everything that happened up to the 19th of June and simply what happened on the 19th of June. The mechanism by which they achieved their, we would say, dishonest plan, and as the judge found it to be a dishonest plan, was to secure Mutaz Tabi's agreement to diverting this sum from the fund in circumstances where, as we know, I'll come back to subjective knowledge in due course, Mr. Tabi had no authority to approve that diversion. And as the judge found, they knew that. So the diversion of the fund's money, of which FIML, as the fund's assignee, complains, is the mechanism by which the plan they instituted in December 2016 was made good. It is therefore part and parcel of everything that I'm now taking you to, in essence, picking out the key parts of it. Now, we say, and the judge found, that their purpose was a dishonest purpose. My job is to vindicate that judgment. My job is to give your lordships the confidence to believe that that judgment was arrived at the end of a difficult 2-week trial with proper consideration by the trial judge of all the evidence which he heard, not little bits of it picked out in a much shorter appeal, which is, after all, an appeal on law and approach, not an appeal on fact per se. So all I'm doing, in answer to Mr. Elias's point that you go to paragraph 359 to see any reference to dishonesty, so you just have to look at that one single section of the judgment. What I'm hoping this is doing is showing you that that's not, as I said yesterday, a fair representation of the judgment as a whole. We have to look back and see what the judge plainly had in mind when he arrived at his decisions in the section starting at 359.
Can you pick up my lord's question to you about paragraph 231? The instructions are defined at paragraph 124 of the judgment, and the judge deals with them as follows. The judge says that the instructions which were given on behalf of FIML and in turn the fund were to achieve early repayment and in that effort to ignore recovery of the fees to which the fund might be entitled.
Yes.
So have I got this right? The judge says that Mutaz Tabi's authority for FIML and the fund extended to giving instructions to Mr. Churchill, Mr. Diallo and Mr. Nuseibeh on behalf of FCM London to achieve early repayment and in that effort to ignore recovery of funds to which the fund might be entitled.
Two comments I wish to make about that by way of submission. First of all, there's no doubt, I think, that FIML would have had that level of discretion under the IMA and to exercise a level of discretion in about negotiating a settlement under the IMA terms. So I do not read, and I don't, with respect, think the trial judge intended that there was any authority vested in Mr. Tabi which was anything other than through FIML, because that was, FIML is the manager of the investment. The second part of it, which...
I'm not sure about that. If you look at paragraph 126, because it was the fund's case that only, by which I mean it means the claimant's case, that only the full board of the fund had authority to waive or fail to exercise any contractual obligation owed or potentially owed, and he rejects that.
Your lordship's quite right. I don't think, if I say so, this affects what this case was about. This case was about something else, because that's the second point I'm going to come on to. The authority to give the instructions, which included instructions which could, as it were, ignore the recovery of the fees which the fund might be entitled to, as the judge found it, related to the deal that could be done on behalf of the fund with Reading.
So Mutaz, in short, had authority to agree that no termination fee would be payable by Reading, but if defendants succeeded in negotiating a termination fee, he didn't have authority to do anything other than cause that to be paid to the fund. That's your position.
Correct. And that is precisely the point, Lord, thank you. That is precisely the point I wanted to make, because if, for example, we complained, we said the termination fee should have been nearer 3 million or whatever the precise number was. We lost on that because the judge found that that was within the discretion vested in them pursuant to the instructions. So presumably, logically, in the light of what Mr. Justice Knowles said in paragraph 124, logically it could be less than 2.2 million or possibly down to zero. But the moment it is negotiated, whatever that sum is, that did not authorise anybody to siphon it off on the basis that it was anything other than the fund's money. And that's the distinction. Mm-hmm. So, Lord, I would respectfully submit that the reservation in paragraph 231, which my Lord Justice Snowden took us back to explore in 214, rightly was held by the judge, did not cover taking the fund's money once the fund had on its behalf that money negotiated for its benefit.
It wouldn't extend to taking the money, i.e. treating those assets as his own, just simply taking it. At some point you'll have to come on to address the question of whether it extended to dealing with it, in essence, to in a way that the contractual structure required it to be dealt with. In other words, if in fact it was excess and could have been paid out, or would in fact have been obliged to be paid out to FIML, then that's not taking it and treating it as if it's your own. It's treating it as it's contractually required to be treated.
Well, Lord, it is treating it as your own because, with respect, because it is it's the board of FIML that must make that decision. Whatever your concerns about the events of 2019, which we had exchanges about yesterday, whatever your concerns about that, it was the board's decision in 2019, not Mr. Atabi's decision in 2019. So the instructions could not conceivably be construed as extending to an ability to deny the proper processes or the processes which the board chose to apply at the time, which is your lordship's concern about 2019. It's their decision. It's their decision whether they want to undertake a NAV or not in relation to a particular.
Where is that pleaded as an allegation of dishonesty? That's depriving the board of the opportunity to make that decision as the basis of dishonesty is very different, isn't it, from simply treating the money as your own to buy a super yacht with.
Lord, I would respectfully submit it's not very different because it is not.
But where was that explored? Well, first of all, where is the allegation of that is the basis of dishonesty that
we undoubtedly put in the body of the particulars of claim, I'd have to go back and find out where it is, that part of what they did was to divert the sum in circumstances where the sum should have gone to the board and the board would have made a decision what to do with it. But the point I made yesterday, which is the critical one, is it is not open to a small s servant of the board to predetermine what the board will do. That's the board's job. Now, the board may, from time to time, taking your lordship's point about 2019, choose to say that they will act as they acted in 2019. That it's their decision. It's not the servant's decision.
I don't doubt that that may be the proper process that should have been followed. You may say, you may be right to say that it is for the full board, or indeed some other proper organ of the fund, to make a decision about how the fund's money should be applied. Let's take that as read as a matter of process. But we're here not dealing with simply the question of what was the right process or what was the wrong process. We're dealing with a question of whether the state of mind and objectively conduct of somebody was dishonest. And I think what I am putting to you is that there is or may be a difference between somebody who simply takes money and uses it as his own without more, just sees somebody else's money and takes it, which is the way that this has been put, and somebody who acts in a belief that the money would be paid in a particular way because of a contractual obligation that the fund is under, and therefore is utilizing money to discharge an obligation that the fund had. And the question of honesty and dishonesty, or what is expected of an honest person in those two situations, may be different because they are two different species of misapplication of funds. One is using it to pay somebody that the fund may be obligated to, but bypassing a internal procedure within the company. That's how it may be seen. The other is simply using the money for a completely unrelated third-party purpose. Somebody just taking the money, stealing it, if you like, in common parlance.
Look,
And the reaction of the honest person put in those two different positions may be different, especially where, for example, if the fund's firm of solicitors is involved, who might be expected to say, hang on, you can't do this. And what I'm asking is whether the way in which I think you're now putting it, in terms of the proper procedure not being followed, and the board not being given the opportunity, the full board not being given the opportunity to decide what to do, is the way in which it was pleaded as an allegation of dishonesty, and then indeed explored in the evidence before we even get to the judgment. I've tried to be as clear as I can. I've spoken very slowly. I've tried to be as clear as I can.
Rob, there's quite a bit there for me to respond to, if I may. Can I start at the back end of it?
Yeah.
One talks about Burgess Salmon as the fund solicitors. I'm not aware of Burgess Salmon being the fund solicitors in the sense that they advise the fund how to conduct their business. They were the fund solicitors for this transaction, instructed, as we have seen, by on a retainer signed by FCM, saying that they had the authority of the fund to act, and Burgess Salmon accepted that. Now, as I said yesterday, when I took you to that document, the fund has never said that they didn't have some generic authority to instruct solicitors to effect the completion of the repayment of the loan. Plainly, they did, and no complaint has been made. I've never advanced a complaint at the trial, but they had gone off and instructed Burgess Salmon in that way. But they were instructing Burgess Salmon on behalf of the fund. So if Burgess Salmon, or purporting to, and that is what Burgess Salmon accepted, so if Burgess Salmon were told by them, please make this payment in this way, Burgess Salmon's brief didn't run to looking up the offering memorandum or the articles of association or whatever it was which determined the fund's processes and tell them they couldn't do it. As far as they were concerned, they were being instructed by the fund. The question is, they were being instructed by someone on behalf of the fund who was, without telling them, diverting money from the fund without authority. That's the difference. But as far as they didn't know that, and they made no inquiry about it. Now, whether it was that when RFC saw the nature of the cancellation notice, they just decided that they didn't understand that and they were going to pay it to Burgess Salmon in one go, it's an entirely different question. I've no idea. I'm not prepared to speculate. That may be the answer to the point your Lordship put to me earlier. So the fact that Burgess Salmon didn't say anything is, if I would say, nothing to the point, because Burgess Salmon would not know whether what Mr. Nuseibeh and Mr. Diallo were doing was or was not done, well, they would have assumed it was done with the full authority of the fund, because that's the basis on which they were instructed. But they weren't. The fact of the matter is, there is one crystal clear issue here which no one can get round. The appellants can't get round it. That is to say, the money was diverted, using the word with a small d for the moment, with no connotation. The money was diverted without the fund's knowledge, without the fund's approval, and without anyone having the fund's authority to do so. But that is not appealed. Now, that issue is not something I have to persuade your Lordship about is correct. So Burgess Salmon's silence, if you like, is neither here nor there. And Burgess Salmon's silence couldn't possibly be a prop for any of these defendants to say, well, they didn't say there was anything wrong, so why should I have thought there was something wrong? Because they hadn't told them the truth. Of course, Burgess Salmon didn't think there was anything wrong. But the question
well,
is...
you can, I think, make the point, which is another way of perhaps saying what you are, but thinking of us as an appeal court, that it was not part of the defendant's case below that everything must have been okay because they involved Burgess Salmon. And that's factually right.
That's factually correct. It's factually correct. But I always like to try and, in this scenario, deal with the real basics rather than, as it were, pleading points or this wasn't taken below or those sorts of points. My point is much more visceral. Whether it was taken below or not, it doesn't matter. It's not the subject of appeal. There was no authority. Burgess Salmon was entitled to assume, once they'd accepted the retainer letter was on behalf of the fund, Mr. Nuseibeh having told them, and they having accepted it, rightly or wrongly, that he could speak for the fund, and was speaking for the fund, he tells them to deliver it to X, Y, and Z account. Why on earth would they question it? That they are not the fund solicitors in the sense that they're looking at the way in which the fund is managed or administered, or anything of that kind. It's not their brief, it's not their concern. So,
is it your case that the board were deprived of an opportunity to consider whether to pay it out, or is it your case that the board couldn't properly have decided to pay it out because it had to be kept in cash reserves? I mean, sometimes you put it one way and sometimes the other, but...
my case is the latter.
Which is it?
My case is the latter. My case is the board should not have paid it out because the cash reserves point is very, very clear. But I always, again, like to try and submit or make submissions on an alternative basis, but on a basis which meets the claim put against us. So that is my primary point. The fund should not have paid it out because this was a termination fee. Now, I readily take...
Had to be kept for all time.
In my reading of it, yes, that would be necessary. But on my reading of the offering memorandum.
Right. So, how was the board able to deal with the monies returned in 2019, contrary to that?
Well, I was anticipating the Lordship was going to ask me about 2019 because they didn't address the point in 2019. I can't speak for why they didn't address the point. The point put to me by Lord Justice Bales was, would I be adhering to the proposition that as a termination fee it should have gone in as staying cash reserves? And the answer to that is plainly yes.
But you put that point in cross-examination to one of the witnesses, I can't remember which one it was that we saw.
Mr. Diallo, I think.
Who gave you an answer along the lines of the point I've just put to you.
Yes.
And where did the judge deal with that in the judgment?
I will come back to that. My recollection is that the judge has certainly not made a positive finding in favour of the proposition that I've just put to your Lordship. I can't remember what he did say about it. But
I have a recollection that somewhere in this judgment there is a sentence where the judge actually comes to the opposite view.
Let me. I recall a sentence, as I've just said. 400. Thank you. Let me just read through and see where this takes us. 442. So, Lord, I don't think that answers the question your Lordship was putting to me, but my recollection is the same as yours. I think it's dealt with it elsewhere as well, and for the moment I can't put my finger on it. I have no doubt my recollection is right, that he didn't find in my favour on the point, but I can't remember as whether he was positively against me on the point. But I'm sure there's another paragraph where that...
He deals with it under the heading of credit at 489 and following, and essentially says, I think, that it's irrelevant what would have happened.
Yes. Well, certainly from 440, one gets the impression that he thought it was irrelevant. But in a sense, Lord, may I try to find some common ground here? Because I don't want to...
It's actually a paragraph 131.
Thank you.
He says, I'm able to make the legal finding 6.2. In line with the offering memorandum, the retention in cash reserves would be to meet any shortfalls in income received or principal repaid. It would not be for all time.
That's the sentence. Your Lordship's quite right. I knew there was an additional one somewhere. The point is, though, the most important point here is what was the proper definition of cash reserves, which just reminding you, because I don't want you to think I'm taking an expanded point from yesterday, they were all familiar with the offering memorandum, but only Mr. Diallo was held to have actual knowledge of the cash reserves point, so I don't want that. And the reason I didn't focus on that yesterday, as I explained, is they were all held to have actual knowledge of the quarterly NAV exercise, and therefore I focused on that yesterday rather than the cash reserves, because they're all three of them involved.
But as I said this morning, what you took us to in the offering memorandum simply says there will be a quarterly NAV calculation, which is unsurprising, but it doesn't say that that is in any way related to the question of what can be done with the termination fee.
Look, I will come back to that, but I can't investigate that precise point on my feet, but I will come back to it. But I was just explaining why yesterday I concentrated on the NAV, not the cash reserves. And the reason for that is the judge has found that only one of the three defendants had actual knowledge of the cash reserves, but all three of them had actual knowledge of the net asset valuation.
So the judge says that the offering memorandum talks about a retention of cash reserves to meet shortfalls in income received or principal repaid, but not for all time. And when this money is eventually repaid by Mutas to the fund in 2019, the money, in fact, goes straight out.
It did. Look, there's nothing I can say about that. As a footnote, by the way, can I say this?
But you're saying it's dishonest. Is this right? You're saying it's dishonest of the individuals to deprive the company of the opportunity to retain cash reserves. I'm struggling to understand where is the obligation to retain cash reserves in the circumstances we're talking about.
I am saying that it's dishonest of these defendants to divert the fund's money without authority when they knew it was the fund's money, and as the judge has held, they knew Mr. Itabi had no authority to authorise them to do so. And because whatever the fund might subsequently do with the money, it was the fund's decision. Whether the fund wanted it in cash reserves or not, whether it wanted to keep it in cash reserve for 3 months or not, whether it wanted to wait for asset valuation or not, or to make a move to deal with it before that situation, are all matters for the fund. And the defendants would have known that. The defendants would have known, without any question at all, that once that money went to the fund would be in charge of what then happened to it. The dishonesty, as the judge plainly found, is that that was a situation these defendants were not prepared to risk. Now, if you stand back from this for the moment, there is a horns of a dilemma for the other side. They say they had Mr. Itabi's authority, had his agreement. They believed him to be authorised to allow them to take the money, half of it. But their case actually is that were it to have got to the fund, they may not have got the money. Why? Because Mr. Itabi may have taken steps to delay it, one of the issues, delay it, or pay them less than they thought they were entitled to. Now, what is crystal clear, and I submit the defendants have absolutely no answer to of any kind whatsoever, is that they knew that money belonged to the fund and should go to the fund. They knew, because they knew enough on any view about the fund's processes, that the fund would then have the decision to take as to what to do with it. And what they did was to ensure that the fund didn't get that money. I don't have to go further than that. This is not a case about whether fund has got a claim in damages of some sort. Maybe if there's a breach of a duty of care, we may get onto some issues there. But this is about, this money belonged to the fund, it was diverted, it should have gone to their bank account in 2017. Now, rightly or wrongly, Mr. Itabi repaid, or his company repaid his part of the money in 2019, when it all came to light. Now, the fund then decided to pay it back to him, and as a footnote, may I say, I don't think anything turns on this, but it arises from a remark of my Lord Justice Snowden yesterday. The money, and there was evidence in the trial bundle about this, the money that came back in 2019 was actually destined for and was used as legal expenses by Fimmel. So it's just because Your Lordship yesterday we'd advanced a false point. And do you not remember the point yesterday when you were saying that we'd advanced a false reason for the money coming out of Fimmel?
I think it may have been me.
Oh, I'm so sorry. Lord just said you're looking at me completely blank. I'm sorry, I'd misremembered. So all I wanted to do by way of footnote was to say that money, in fact, whatever the process by which it came out of the fund to FIML, it was in fact then straight into legal fees. And there was evidence to that effect. I just wanted to make that point. I don't think anything turns on it.
Right. Would it be fair to say you're really inviting us not to lose sight of the big picture here? The big picture being you only need really to look at the position vis-a-vis the fund.
Yes.
Because it's its own money to which it's entitled.
Yes.
And therefore, the defendants had no right, acting honestly,
To divert it.
to divert it, or at least deprive the fund of deciding what it should do with its own money.
Yeah. And insofar as the defendants seek to excuse and explain their conduct, as they did at trial, with all these various pieces of evidence, His Lordship was uniquely placed, that is to say, Mr. Justice Knowles, uniquely placed to make a decision about whether the excuses and explanations put forward were themselves true and honest. And he found they weren't. And at the end of the day, we would say that is the beginning and the end of this appeal. That the appellants can't come here and have a rerun of the trial. They have got to overcome the proposition that there was undoubtedly a diversion of the fund's money without the fund's authority. Now, they came along, and on the face of it, it wasn't an accident, it was done deliberately. So on the face of it, that looks like a very good claim. Their explanation is, well, we thought this, we thought that, we had a profit share agreement. The fund itself was a party, knew all about the profit share agreement. We weren't doing anything wrong. We could take the money under the profit share agreement from above the fund, between the fund and FIML. It didn't matter. All completely above board. It was all nonsense. Found by nonsense by the judge, which it, with respect, always was. And then what was left of their explanations has been assessed by the trial judge. He's assessed those explanations as being themselves untrue. And if that's right, then having an investigation about what the fund may have done in due course of that money is neither here nor there. And I support that proposition by making the obvious point, which they will have known, couldn't possibly say otherwise, that if the money went to the fund, it would be the fund that decided what to do with it. It wasn't for them to prejudge it. They would have known that. And the fact that this was the fund's money and they had absolutely no connection to this money is going to be clear from the next document I'm going to ask you to look at. So could you look, please, with me at, I think it's the second supplementary bundle. You could go to the second supplementary bundle, I think, tab page 443 and 444. Let me just find you a tab number. My recollection is tab 29, but I don't want to be firm about that.
Yes, it is.
Yes, tab 29, thank you. So this concerns cross-examination of Mr. Diallo. And this relates to the question of a bank account in Cayman. Will you forgive me for a moment? Could you just give me where the chat is? Yeah, the 7th. It's the 7th of June. Lord, I'm sorry, I've got a reference here to some Bloomberg chat. Oh, I'm not sure where I can reference it for you. Can I read it to you to start with, and then I'll make sure you're handed a copy of it.
Page 150 of the supplemental
150 of bundle 1. Supplemental. So could we, let's go to supplemental to start with then. 150.
Yes.
No, it's the in the additional bundle comes up because that's
That's where it is. I'm so sorry. It's actually in the U bundle.
No, not the U. It's the one handed up. Because it was the one it's the final tab.
Right, thank you. Right, there's an easy place to find it. Thank you. So if your lordship would go to this thin bundle which we've been looking at this morning, and it's tab 6. So let me give you the context of this. If you look at the second line at the top, you'll see that it involves Mr. Churchill, Mr. Nuseibeh, and Mr. Diallo. So all three of them involved in this. And this is all about, let me give you the context, it's all about how they are going to get their bank in Cayman to accept the payment for compliance purposes. So will you read, can I give you a timing and see if you can pick it up there? If you look at the left-hand side, second column, and you go for a timing of 13:23:09, could we pick it up there, please? Read Justin EFG, that is EFG Bank in Cayman, which was IRL's bank in Cayman. Will this Justin guy have issues with the FIR receiving this amount from RFC? No, we will just need to share the agreement. Well, that was my point. There is no agreement. But yeah, whatever, let's see. The letter should be sufficient. The deed of release is fine. It's a termination fee. Yes, but why to FIR? Please listen to that. I think what we then see is a text version of a smiley face. What's FIR's link to the deal? None. Just the way EFG is, they have been a nightmare. So then we get negotiated the exit, so paid a termination stroke advisory fee. Right, okay. Now, there can be only one meaning to that. They've got no right to the money so far as the fund is concerned. They can't show a contract giving them a right to the money. They might have a deed of release, to which the question is, but why does it go to FIR? Because it's a termination fee. And the answer is, we'll tell the bank it's a termination stroke advisory fee. That's not true. That was a plan hatched up by the three of them to have in their back pocket a way of misleading a compliance manager at a bank in the Cayman Islands to explain their receipt of a sum of money to which they could show no entitlement. Now, I did cross-examine Mr. Diallo about this, cross-examine Mr. Nuseibeh as well, but we've got Mr. Diallo's cross-examination in Supplementary 2, tab 29. And I'm not going to read that through. It covers page 443 and 444. But I did press him hard about that. And I asked him, wouldn't they need to show him honest and truthful documentation? Bottom of the right-hand page, the first page, bottom right. And I questioned him at some length about that.
So which page are you on of the transcript?
Well, my lord, I was on 443. I'm sorry, I was then picking up that at the foot of transcript page 36. If your lordships were making a note of the passages you might like to read in full in due course, it's 1 to 10, page 33, 11 to 25 on page 34, 1 to 10 on 35, 19 to 25, his answer line 1 on 35, and then over the page, more or less the whole of page 37 and the first half of page 38. Would your lordships prefer to read that now, whilst I stay silent?
Sorry, I haven't caught up with exactly where we are looking. This is in supplemental bundle.
Lord, I'm in supplemental 2,
Yeah,
tab 29,
thank you.
page 443.
The problem which they were addressing, that IRL had no right to the money, would arise, wouldn't it? Whether the money was wrongly diverted, as you say, or if it had trickled down as the defendants say it ought to have, because on either view, IRL hadn't done anything. It was simply a repository for the defendant's share of what they were going to get from this deal. And you specifically put that the party that should have been paying into the Cayman bank account was the fund, and he agrees with that, but it wasn't, was it? It would have been FIML or FCM.
It would have been perfectly possible for there to have been a document agreed, signed by the fund, authorising the payment into IRL's bank account. Whether that would have stood as consistent with FCM's position is a different question. So what this is about is not about saying, how do we persuade Justin at the bank that we're taking it rather than FCM. This was about them having no link to the fund to receive the money, and that arose because the only document they could show, as we've seen in the chat, the only document they could show was the deed of release. So this wasn't about it wasn't about a connection between IRL and FCM. It was uniquely about a connection, no connection between IRL and the fund. Now, their answer to that, let's just explore. If I write about that, and your lordships agree with me, let's explore what it tells us. What it tells us is they didn't go, which was the obvious way to deal with it, just ask for the fund. Ask the fund via Mataz, who was supposed to have had full authority, and JVA authority, PSA authority, and all the rest of it, just to sign a document on behalf of the fund saying we authorise this money to come into your bank account for work that you've carried out on our behalf. That would have been quite sufficient for, I would imagine, for a compliance officer in any bank. So what this is about is the only document they can get is the deed of release. And funnily enough, they don't feel able to go and ask the fund to produce the authority letter to which I've just referred. And yet they ran a case at trial which the judge rejected wholesale, that they believe that Mataz had authority. How can that be right in circumstances where all they had to do was to ask him to sign a document? If he had authority to allow them to take the money, why didn't they ask him to sign a document authorising, on behalf of the fund, authorising that payment? They didn't. And they didn't because they knew the fund hadn't agreed. That could be the only reason chat about Justin EFG Bank. I'm going to press on because I did say to your lordships that I'll try and give you an early day. I think that opportunity may have slipped past us, but I'll do my best. I did say I would take you to the placeholder reference, so you had that. So the placeholder reference, if you go to the unagreed bundle, you'll see, go to page 27 of that, which I think is in tab 2. And the passages I think your lordship may like to read or ought to read, internal transcript, page 53.
I'm sorry, I've missed the page or bundle number.
Well, the unagreed bundle, so we're calling it the U bundle, it's the one that Malone and Friend put in. Lord, I know you're making notes from time to time, and I'm going too quickly, but forgive me if I'm not watching.
Sorry.
Unagreed.
Yep.
Tab 2.
Yep.
Page 27.
Yep.
Can I ask you, please, to read through internal page 53, so that's transcript page 53, starting at line 21, down to the foot of 54, 55, on the first 12 lines of 56. So, Lord, I did say I'd take you to that. It's absolutely clear that the learned judge had that passage on that cross-examination in mind from parts of his judgment, and it was open to him to make of it what he wished. I now need to move from the date we've been talking about, which was the 7th of June, and I now need to move, please, to the 14th of June. So may I emphasise what I've said before, that nothing so far has been discussed between the three individual defendants, pursuant to, approved by, following discussion with, or agreement from Mutazza Tabi. So we're still in the situation where they're on their own. Now I want to take your lordships, please, to the judgment, page 282, on page 168. Judgment, paragraph 282, page 168. Now, Lord, this is a part of the judgment headed, I lied so much just now. So here we are. If I haven't got time to go through all of this, but the underlying Bloomberg chat, if you ever want to look at it, and I hope you will before forming your final views, is in the supplementary bundle at page 153. But those chats are horribly difficult to read because of the way they're set up. So I ask you to read it, but I'm bound to say a heavy heart, but I think the whole of it ought to be considered. You've got large parts of it set out in paragraph 284 of the judgment. There's also, just for your reference, a passage which you may wish to look at in due course, page 154 in the transcript, the chat reference I've just given you, which the judge hadn't picked up. But can I, in the interest of time, commend that to you, because, as the judge says, it understandably featured in the cross-examination, as one might anticipate. And the question here then comes back to a generic theme that I picked up earlier, which is it's not, I would say, the fair way of looking at this judgment to have the appeal proceed on the basis of snippets of explanation given in witness statements or in cross-examination by the defendants and say, well, look, if that's true, they obviously had a clear defence. The question is, what was believed in relation to that? What you will see in the Bloomberg chat and the paragraphs that I've just asked you to accommodate me by reading outside advocacy hours is that Mr. Nuseibeh was cross-examined at length on what he was lying about. And he said what he was lying about, and the judge didn't agree with him. Can we pick up that disagreement and go straight to paragraph 289 of the judgment, page 171. Para 289, well, page 171. I can accept that Mr. Nuseibeh was uncomfortable with the fact that he'd not been transparent over the risk of default. So, Lord, can I just unpack so you know what's behind that? Mr. Nuseibeh was saying that there was a risk that this termination deal might not complete. And he was nervous about dealing with Murtaza Tabi in respect of that potential failure. The judge accepted that. I am not prepared to accept, the judge went on, that this was the principal respect in which he felt he had lied. That was rather over the amount of the fee where he had also not been frank and transparent. And what you will see when you read it is that they were trying to decide what, if anything, to tell Murtaza Tabi about the level of fee that they had negotiated. Now, if they were acting honestly, one might have imagined that telling him what fee had been negotiated would be the first thing they would do. But we know that they didn't want to do that because it's quite a large sum of money, and they hadn't yet worked out how they were going to ensure there was no risk of them not getting their 50%. The judge went on to say the reason he had not been frank and transparent over the amount of the fee was because all three of Mr. Churchill, Mr. Diallo and Mr. Nuseibeh were concerned to keep their options open over the destination of that payment. So if your lordship asked me a question about one of these communications earlier, about whether on the face of it it showed dishonesty, what I'm asking you to accept is that when you look at all these communications from December through to June, it shows a plain pattern of dishonesty. Now, we know that on the 19th, there was agreement, approval to this payment. We know that when that happened, Mr. Tabi, they say, the other side say, maybe that's all we've got because my evidence about what happened at that meeting is slightly different. That's all part of the bonus fee representation, so I can't go there. But even on the other side's case, Mr. Tabi's first response was, well, why doesn't it go to the fund? But leaving that to one side, what we have here is a situation in which the way in which the events leading up to the agreement on the 19th had themselves been the subject of, frankly, dishonest planning and lies to Mr. Tabi. Now, sadly, I didn't vindicate the bonus misrepresentation fee lie, but there it is. I have to live with that. But it doesn't alter the fact that leading up to the 19th, they had misled him. They'd misled him deliberately. They'd misled him as part of a plan which they'd hatched in December 2016, and they were still, even at this stage, after they'd negotiated the fee, were holding that back from him. In Mr. Diallo's case, a fellow board member. In the case of Mr. Nuseibeh, a director of a company which employed him. And one just has to stand back and think how unimpressive that is. He lied to his boss. And he lied to his boss as part of a plan which they had hatched, which was going to allow them, by hook or by crook, to avoid any risk that this money would be taken away from them. The only way they could achieve that was to divert it from the fund. And to divert it from the fund in circumstances, as we've just seen with the AFG, where they could point to not one document, nothing, authorising them to have it. Where they say to Mr. Justice Knowles, and they say to you in this court, they genuinely believed that it was all okay because Mr. Atabi had authority. Why not just have him sign a piece of paper on behalf of the fund saying it? The reason there's nothing to that effect, and no request to him to that effect, is because they knew, as the judge found, they were not entitled to it. They knew he had no authority, because if they thought he'd have authority, they wouldn't have been burdened with how to lie to their bank manager in Cayman about how to explain the receipt of the money. So I've got you up to paragraph 289 of the judgment. I then wish to go on, please, and just, again, I'm so sorry to do this, but time is not on my side. There follows a significant passage of cross-examination, paragraphs 291, 2.5 pages of it, and 292. And I just want to see where that then, and it goes on through to 295, in fact. So may I just invite you, without burdening you unduly, to have in mind to have a quick read through that in due course before forming conclusions. But can I say that we go to 296 and see how the judge formed a view about the cross-examination he had chosen to put in his...
And that's his conclusion from all the 2 pages he set out, isn't it?
296, yes. Yeah. So the point here is that I want to emphasise is this is not a judge who's just filling in blanks without thinking about the evidence that's sitting behind it. And I have used the expression more than once that the judge found that the 3 individual defendants were not prepared to risk the possibility that the fund had authority over its own money. And the expression that I've used because it's written out in black and white in paragraph 296. It would seem also a fair possibility to say that they didn't want it. It wasn't just a question of not wanting it to go to Fimmel. They didn't want it to go to the fund. Now, we can't say what the judge made of this because he hasn't, I think, referenced it specifically. But could we go to supplementary bundle, please, page 330, 330. I'm pretty confident it's going to be in bundle 2. It's in my bundle 2, tab 26.
Sorry, so you accept that what the judge is saying at 296 as the conclusion to this evidence is that their concern was to avoid a situation where Mutaz Utabi would say that the payment must go to Fimmel.
I can't look behind anything the judge has said, and I'm not seeking to do so.
Right, but sorry, have I written down wrongly what you just said? You're about to go to say it wasn't just that they wanted to avoid a situation where Mutazatabi would say that he wanted the money to go to FIML.
Yes, I'm now going to show you a different passage, which looks as if they were also explicitly concerned about it going to the fund.
Right.
So
Right, okay, that's fine. I'd written it down correctly. Sorry.
yes, you absolutely had. So I was expanding the point, if you like. It wasn't a witness statement supporting paragraph 296. So volume 2 of supplemental, tab 26, page 330, paragraph 90.
Sorry, just supplementally bundle 2.
2, tab 26. I'm trying to do tab references as well, just in case we're all in different tab splits.
Yeah.
Page 330,
Yeah.
para 90. So what he says here, this is Mr. Nuseibeh. I'm going to ask you to count down 1, 2, 3, 4, 5. That's 5-line money. My worry was that if the money went into the fund before distributed, Mataz might find some way to improperly delay the payment or take off more money for himself. So it's quite clear from that, I would respectfully submit, that he was concerned that if it went to the fund, that would give the opportunity for Mr. Utabi to disadvantage him and his colleagues. Now, this is extremely surprising if in fact they had a genuine belief that he spoke for the fund and agreed with them on the 19th that the money should go directly. Why on earth would he have that concern if Mataz spoke for the fund?
So what he says is a concern about going into the fund before being distributed. So he's not concerned that the fund won't pay it out, but he is concerned that they will pay it out to FIML, and that once it gets to FIML, they won't get what he regards as their fair share.
Lord, with respect, I think it might be wider than that, because distribution there would be distribution from the fund, I would respect to submit. So he's concerned that if it goes into the fund, there may be delays in it coming out of the fund. That is one way of reading those words. I would submit the right way. Now, we haven't got in the judgment any specific finding about paragraph 90. So I can't say what, in the full analysis, His Lordship made of that evidence. But His Lordship at trial undoubtedly came to the view that they knew that Mataz had no authority, and they knew that they had that the money belonged to the fund. So when we come back to the basic propositions of our case, we would submit they are clearly made out. And much more importantly, insofar as the key findings of fact are concerned, I would hope by now that this court has sufficient confidence that the judge had before him the material from which he could have made the judgments that he made. So now this is not a factual appeal, it's a legal appeal. The only attack that Mr. Elias can properly make is that there wasn't material before the judge for him to have drawn the conclusions he has drawn.
Well, he can also complain that the judge didn't explain his conclusions or support them by any evidence.
But I understand that, but the lack of explanation goes nowhere with respect if in fact the material is there. So what this is about is whether this court has confidence, or perhaps I should put it a different way, given the uphill struggle and the high threshold of setting aside this judgment that the appellants face, is whether the appellants can say that this court can have no confidence that the trial judge did not have the material before him to reach the decision, and therefore it is a decision which can't stand. And what I'm trying to say to you is that if you read 500 paragraphs as a whole, and the material, and I've only been able to take you to the tip of the iceberg of that material at the time available, if you read the material that he had available to him, did he have material upon which it was proper for him to conclude that he rejected the honesty of their explanations?
Unless the appellants can establish some error of approach or principle or something of that kind. I mean,
Yes.
the normal test on matters of fact, including questions of evaluation, however difficult,
Yes.
is that an appellate court has to accept them, unless it's the really rare case where it's satisfied that no reasonable judge could have come to that conclusion,
Yes.
whether or not we as the appellate court would agree with it.
Indeed. And Lord, we took this section of our skeleton argument, as you probably read, rather shortly. What I hadn't anticipated quite is that the learned friend was going to put it on the basis, as he put it in his opening on Tuesday, that there was material which undoubtedly showed the judge was wrong. And in my respectful submission, that won't do. You can't cherry pick. I suppose every advocate cherry picks, but you know the basic proposition I'm making here. If one is going to try and undermine, attack, set aside an experienced judge's conclusions of written and oral evidence over 2 weeks going to people's state of mind, that is an uphill task. All I'm doing is not trying to prove my case all over again. I don't have that obligation. All I'm doing is providing your lordships with the material to feel confident that this judge had before him plain material from which he was entitled to draw the conclusions he did. In other words, it is not, the material is not available to Mr. Elias's side to show that there is an error of law here, of such as to allow this court, putting it, if I may say so bluntly, allow this court to set it aside, given the high hurdle that he has to overcome. So there's no doubt that we've discussed some of these paragraphs before. I was going to take you to paragraph 350 and 351, but I think we've looked at that already. And what I'm now going to do, please, is to move on to some more general points. So you'll be pleased to know, I hope, for the moment, that concludes the documentary trawl. Now, to a large extent, in a sense, that this appeal has coalesced around two propositions from the appellant. One, that the termination fee would be paid out by the fund in any event, ergo they didn't do anything wrong, and the TAS had authority that they could have it, ergo they didn't do anything wrong. And we dealt with this in part at paragraph 54 of our skeleton, just for your cross-reference, but I'm not going to read that out.
Sorry, can I just...
My lord, of course.
Sorry, you just... Before you moved on, you just referred to 350 and 351.
Yes.
I'm just reminding myself of that.
This is about...
about whether the monies would have been paid out.
Yeah, this is the 2019 point.
Press.
Yeah.
Well, the judge says in 351, views as at June 2017, I cannot accept that this is what would have happened. And I note that the defendants did not believe it at the time. What's the basis for that finding?
Lord, I have not seen that referenced elsewhere in the judgment. I'll be reminded from behind if I'm wrong, but I think your lordship is right that there's nothing, I can't recall anything sitting behind that. But Lord, the point I've been making is this. If they had believed that the fund would have paid it out at the time. May I ask you, I was always taught to say a forensic question rather than a rhetorical one. May I put then the rhetorical question? If they thought that that was correct and that it was inevitably going to be paid out in any event, why did they not have a document of authority from the fund authorising the diversion of the funds? Now, if one's looking...
Sorry, but as I understood it, the argument is, and perhaps this is the point that was picked up in paragraph 90 that we were just looking at, that it was precisely because it would be paid out immediately by the fund to Fimmel that they were concerned, because it's because when it gets to Fimmel, it will be diluted by Mutaz taking off money for, as it says, himself and Hassan. That's Hassan, who is the ultimate owner with Mutaz of FMB, and it goes out under the placement agreement. So in other words, the concern is not that it, it's precisely because they thought it would come out from the fund and go to Fimmel that they were concerned that when it gets to Fimmel, it'll be diluted.
Lord, may I say may I say with the greatest respect that is not the right approach? Forgive me.
Yeah.
Because what you're doing is you're assuming that 3 lines from a witness statement are true, and we can't make that assumption.
Well, oh, sorry, it's the witness statement you just took us to.
Yes, because I think there's a different way of reading that witness statement. I think that there's a different way of reading that they were concerned it would go to the fund, and before distribution from the fund, there might be delay. Your Lordship is reading it differently from me. One of us might be right, one of us might be wrong. It's pure speculation. But the question that arises from it is this. I do not have to prove in this court that this money would not have been paid out in 2017. I am answering a point that Mr. Elias raised, where he says it would have been paid out in 2017. Now, he has to advance that proposition. Whether it gets him home or not is a different question, but he's raised it, so I'm entitled to meet it, and I'm obliged to meet it. The judge dealt with it. He's got to say that this paragraph 351 is unsustainable.
I think paragraph 351 is rather loosely expressed, because 350 says that the diverted sum would immediately have been paid out to Fimmel and would have been available to be distributed. Well, yes, the defendants agree with that, but their concern was that it would not in fact have been distributed. And that's what the judge means when he says, I cannot accept that this is what would have happened. In fact, this, which he sets out, the antecedent is not availability, but payment out. That's what it's perfectly clear the defendants were concerned about, that the money would get to Fimmel and would not then reach them, or at least would not reach them in the share to which they thought they were entitled.
Well, Lord, that may be the right way to read it.
And I actually think that the word "not" in the third line of 351 is probably an error, because it only makes sense if you say it's precisely because of their material concern that this would or might happen, i.e. that it would be immediately paid out to Fimmel. That they took the steps to route half the sum of the termination payment to themselves directly.
Well, I would respectfully read it the other way.
Okay.
It was precisely because of their material concern that it would not be paid out that they took the steps to route it that way. But there is, but Lord, I'm not going to say this is a key paragraph. It's a paragraph we've all looked at. But it is not for me to prove that the funds would have remained in the fund. I don't have to prove that point. I've already won the trial. All I'm meeting is the proposition that the trial judge should be overturned on the basis that you are, as it were, satisfied that it would absolutely have been paid out. And my answer to that is, you cannot be so satisfied because what material is there which allows you to be so satisfied? That is the 2019 payment. That's what's excited your Lordship's attention to this. And I understand why. But what would have happened in 2017, or might have happened in 2017, or what these defendants properly thought about what might have happened in 2017, is very different from what actually happened in 2019.
Yeah, okay. I mean, I understand your point. Sorry. I'm afraid I was being much less
I'm sorry.
Machiavellian than you think. I was only following the paragraph references that you'd asked me to read, and I was just trying to understand those paragraphs while we were going.
If I sounded as if I was accusing you of being Machiavellian, I do apologise.
No,
I had no such intention.
I'm afraid you're just reading too much in. I was just reading along
All right.
and couldn't quite understand the paragraph.
I've been far too defensive, and I apologise. Absolutely, I withdraw everything I've said. Can I put it a different way, though? Because it is.
But you are right. I think there is a point which you do need to grapple with, and you have grappled with, about the relevance of the 2019 documents. I mean, that's right. But I was actually just asking what this paragraph meant. Sorry.
Well, I was being far too defensive. I'm sorry to take it lightly. I don't, but I do apologise.
It's all right.
So the situation here is that I come back to the point that I've laboured already this morning, which is that if this was so very easy, that is to say, it would all have been agreed. Why don't we see a document to that effect from the fund agreeing that the fund's money could be paid out to two different places? Why don't we see that? And the reason we don't see it is precisely the sort of evidence or lack of evidence that the trial judge would have had in mind when concluding, making the conclusions about these defendants that he did make.
And did you put that to any of the defendants at that point?
In those terms, I doubt. I may have done. I can't recall over 7 days of cross-examination now precisely what I put to you.
Isn't it a bit difficult for us to sort of accept that argument if you didn't actually put that point? I just put to them, if you believe Mutaz had the authority of the fund, why didn't you just ask for a document to that effect?
I'm sorry, that's the narrow question you're asking me. I think, yes, I'm pretty sure I would have put that to them. We'll check the transcript, but okay. I don't think there's any. I don't think there could be any doubt that the detail of the cross-examination would have included material from which the judge could form a view about that. But I may be wrong. I may be misremembering. It was 2 years ago, and I haven't made a study of the entire transcripts, I'm afraid, for this appeal. But the point I was making is that whether I put that precise point or not, wouldn't, I would respectfully submit, affect adversely the judge's ability to make a finding that in diverting the sum, the defendants knew perfectly well that they were doing so dishonestly. They weren't entitled to that money and there was no authority. That's the point. When it comes to it, the issue about whether they thought the money would come in and straight out again, the contractual shortcut, gets them nowhere. For the reasons I was trying to explain yesterday, it doesn't alter the basic visceral point that they conspired, the greatest of respect to them, dishonestly, to ensure that that money did not reach the fund, because they feared that if it did, they may be disadvantaged. And them turning round now and saying, well, you can't criticise me for being dishonest, because if it had gone to the fund, it would have come straight out again. That, with respect, does not meet the point. In other words, it comes back to something that I said to you yesterday in submission. Mr. Elias might well be right, that part of this investigation may depend on what question you ask and what the question the judge asked himself and which one he answered. But coming up with a question to which you know or you think you can point to your clients having given an answer which, if unchallenged and believed by the trial judge, would have saved them, doesn't help them. But they start with the proposition that they diverted someone else's money without the authority of someone else. And they can't have thought they had the authority of the fund because they'd have a piece of paper from Mutaz agreeing on behalf of the fund that it could be diverted. It's the EFG point. Why?
Well, in your case, even if they had a piece of paper from Mutaz agreeing the money could be diverted, they would know that he had no authority to sign that.
Okay.
Makes no difference whether Mutaz's agreement was written or, as it was, oral.
Well, your lordship is quite right. But in a sense, I suppose what I'm doing is meeting points in the alternative. Their case is they believed he had authority. So I'm meeting that. If they genuinely believed he had authority, then we would see such a piece of paper. There would be no reason for this to be a paperless trail.
I don't think their case is that they believed he had authority because the judge found that they knew that he didn't. Their case is that it was a contractual shortcut. They were doing something which they knew they shouldn't really do, but it was all right really because it was only short-circuiting what would have happened or should have happened.
But it wasn't all right really because it wasn't their money. And it wasn't for them to take a decision what the fund would do with it. And I would respectfully submit that Mutaz Tabi also sat on the funds. Their concern that they would be disadvantaged applies at fund level and field level. Does it make any difference? What they wanted to do was to engineer a situation in which, without any documentary trail at all, and in fact contrary to all the documentary trail, they would have half of that money put into their bank account before it reached the fund. And they did that by, on their own case, on the judge's findings of Mr. Nuseibeh, and on Mr. Nuseibeh's own words, by misleading Mr. Otabi. I lied so much. They did it by cooking up a scheme as long ago as December 2016 to ensure that they got that money somehow. They didn't know how. They then had to find ways to mislead their bank manager in the Cayman Islands because they couldn't find a documentary trail justifying the receipt of the money. And yet they come to this court and say, you should exculpate them from clear findings of dishonesty in circumstances where what they thought they were doing was simply taking the money to which they would be entitled in any event. It didn't matter because the fund would pay it out automatically. Ask the fund to approve it would be the simple proposition. But they didn't. Well, why didn't they? They didn't because they knew it wouldn't give it. That's the point. The point is, if the logical conclusion as to why they can't point to a single sheet of paper or a single email from the fund justifying this, one has to ask oneself why. And the answer to the question why is because they knew what they were doing was wrong and they did it dishonestly. We shouldn't then get involved with respect in deciding whether that obvious dishonesty can be in some way answered or ameliorated by reference to whether the funds would have been paid straight out. Because I say they can't have known that in circumstances where they didn't have the courage to ask the fund to approve what they were doing.
When you say they knew what they were doing was wrong, the wrong is what? Not giving the board of the fund the opportunity to not pay the money out.
Well, no. What they're doing is wrong. Is paying themselves someone else's money to which they know they're not entitled. Now, then the point is put against me that they had a belief which exculpates them from dishonesty, that they get the money eventually. Now, there's two answers to that. First of all, this whole scheme was cooked up because they didn't believe they would get the money eventually. And secondly, I'm entitled to answer that point, which is not me proving my case, but answering this appeal. I'm entitled to answer that point by saying, if they believed that the fund would pay it out anyway, and it was that easy, then one would expect to see a trail, an audit trail to that effect. And the absence of that audit trail allows this court to be satisfied that it's a thoroughly bad point.
If they believed that the money would be paid out immediately because because there was a contractual entitlement of FIML to it as excess, and they have the agreement of Mutaz as the owner of FIML that it should not go to FIML, which is where they think it's going to be diluted. Why you say that's dishonest?
Yeah.
But the dishonesty can only be that the fund has not had an opportunity, or the board of the fund has not had the opportunity to consider something which the fund, on this hypothesis, is obliged to do immediately anyway.
Well, it wouldn't be obliged to do it.
No, but their belief.
No, Lord.
It's their belief that at the moment you're going to come back to it, but if, as I'm just looking at paragraph 350, 351, since this is going to the nub of some of the points we've been debating. If their belief was that the money, if remitted to the fund, would immediately go to FIML because FIML had an entitlement to be paid it, their concern is that if it gets to FIML, it will be diluted. But they have the agreement, as the judge has found, the consent of Mr. Mutaz on behalf of FIML for the money to go elsewhere. Why do you say that's dishonest so far as the fund is concerned?
Because they know they're not entitled to that diversion. It's the fund's money. They've got no authority from the fund to divert it. None whatsoever.
But as my lord put to you, we'll have to look at what the judge found about what they believed in relation to the authority of the fund. But if their belief is that money is going to come out immediately, you say it's your point. Your point must be that it's dishonest to not, as it were, give the board of the fund the opportunity to do that which the fund is entitled to.
I'm cavilling against two things, if I may say so. The first is, your lordship is assuming, which I'm inviting you not to assume, that their assertion that that is what they believed was true.
Does your case in response to the contractual shortcut point come to something like that? Let me see if I can try and pull together what I think you've been submitting to us over the last day or so. That they didn't actually believe they would get the money. That was the whole point of the diversion. That they believed that they should get it, but they did so far as the trial was concerned, on the basis of a profit share agreement which the judge has found was never made. That if there was no profit share agreement, the dilution which they were concerned about was not something which was wrongful at all. It was simply a consequence of the contractual structure which enabled FMB to get paid by FIML, if that's what FIML thought was the appropriate thing to do. And that essentially, therefore, the defendants were not happy with the contractual structure which the judge found that they had agreed, and decided to ensure that they got the 50% they thought they were entitled to. And the question then is whether that is dishonest on their part, and that's an objective test, and you say it is. I mean, is that really it?
That's what it comes to.
Yeah.
The debate, I shouldn't call it debate, the submissions I'm trying to make to Lord Justice Snowden is to meet a point put against me. It's not my case that I'm proving a negative. So the concern I have is that your lordships may be seduced by the way in which the appeal has been put into thinking that they had a genuine view that the fund would pay the money straight out. But that won't help them. Shouldn't help them.
Well, And even if they do have a subjective view of that nature, that's only part of stage one of the dishonesty test. I mean,
Yeah.
So assuming in their favour that they did have such a belief, we still have to ask ourselves what really is the jury question, the objective question.
Were they being dishonest?
Were they being dishonest by the standards of ordinary people? And I think you say no, and in really exhorting us again not to lose sight of the big point, which is that this was not their money.
So
That really was almost the end of it.
precisely, and we would respectfully submit that if we keep with the basics, that the way in which the appeal's been put is encouraging the court to divide, separate different parts of what is a integral story. And that, I respectfully submit, is a false piece, and the court should ignore it. The diversion of the money from the fund, which they knew they weren't entitled to do on the judge's findings, they knew that, was the machinery by which they achieved the plan that they hatched up secretly starting in December 2016. That was plainly a plan which involved misleading on any view. Their boss, not Mr. Diallo's boss, they were joint directors, but you know what I mean by that. It involved them misleading Murtaza Tabi, which Mr. Nuseibeh did, and which the judge found he did. It involved them finding various ways to describe to him what they were doing, which weren't true, not telling him how much, all dishonest. It involved them cooking up a scheme, a story for how to get this money into their bank account if challenged. All dishonest activity. This is not the activity of honest people. This is all the activity of dishonest people. We would say plainly dishonest. They were engaged in a dishonest enterprise. And all you've had pitched to you in this appeal is that you should accept that they had one aspect of honesty among them, amongst all the lies and the deceit and the dishonesty, one aspect of honesty, which is that they believed that this was purely a contractual shortcut. That's all. But it's a contractual shortcut which takes away money which does not belong to them in circumstances where they have plotted, planned, secretly, that that owner will not be asked. And if they were not engaged in a dishonest enterprise, it was a very simple proposition to resolve. They just asked. And the fund could have sent a letter, Mr. Whitworth could have been asked to do it, Mr. Atabi could have been asked to do it. I understand that on the judge's findings, if Mr. Atabi had done it, it wouldn't have been sufficient on authority. And I entirely take Lord Justice Bowser's point on that. I'm just dealing with their state of mind. So, because on their state of mind is a dishonest state of mind, and they cannot parse or separate the whole story and just say on one point that they believed that this was some form of contractual shortcut, and therefore they were acting honestly. In circumstances where the judge has held unquestionably that they were not honest in and about the diversion of the fund's money. So I would invite your lordships to stick with the bigger point.
I see you looking at the clock. I don't know how much more time you want to spend on the facts. It's up to you, really. But there were various submissions about the various causes of action which you rely on, and fiduciary duties, and who owed them. And
I've got to go. I've got to go through that. Can I have been promising Lord Justice Snowden that we will go back, however, to the judge's findings, and I'd quite like to do that finally. So can we start at paragraph 368? Because there is another, I was going to call it a technical complaint, that I think does it ill justice. There is another complaint here, not only that the judge hasn't had sufficient material or reasoning for his judgment, but also that he hasn't addressed the two-stage test. And we respectfully disagree. We think he has. And put shortly, we read paragraphs 368 to 372 as being subjective findings.
Sorry, 368 to
372.
372, thank you.
And in respect of Mr. Churchill, 376.
So one thing that puzzled me about 370 is how could FCM London ever be in a position to declare dividends if it had loans and it had to pay salaries and it was deliberately not receiving any money because it was being kept lean and so forth. It was going offshore.
It wasn't not receiving any money. It wasn't receiving the Table 17 money. The first items of the Table 17 money, but I wouldn't want your lordship to think that it was starved of any cash. And the answer to that is it would receive dividends only when it was able to pay them, which I think that's all the trial judge was saying at that stage. That would be the correct mechanism for them to receive that money. And if the company had borrowed money or had, for whatever reason, in order to pay its salaries and so on and so forth, then it would be perfectly proper for money due to the fund then coming down through the contractual structure to the FCM to repay it. I think that's all he was saying.
But I mean, in fact, the fees payable to FCM under the agreement would in practice be paid offshore to FCM Cayman or divided between FCM Cayman and Mutaz's company.
I think the only payments offshore were the introductory fee payments, which were third-party paid, not fund paid, which went offshore in the Table 17. The reason I majored on Table 17 was precisely to bring to your lordship's attention that the underlying premise which puts the termination fee from Reading as the last fee line in Table 17 is wrong. And that's the whole question of Mr. Diallo saying he's found an idea. He's found an idea to try and say that the termination fee is the equivalent of an introductory fee. And it plainly isn't. Because the introductory fees, this is the main, perhaps I can re-emphasize this point, my lord, because I may not have made it clear enough yesterday. The introductory fees were never fees paid to the fund or due to the fund. They were fees agreed outside the fund for FCM to receive an introductory payment from the fund's counterparty, from someone else.
I understand that. I was just wondering whether, although the judge sets out what the contractual structure seems to say, whether in practice it would ever have worked in that way, because rather than putting profits into FCM London and then declaring dividends, there would have been a shortcut so that money was simply routed offshore. That's a large part of the whole purpose of this arrangement, wasn't it?
I'm being asked just to remind your lordships of paragraph 303, where the judge did deal in part, I think, with the point that you're putting to me, or one of the points that you've made. So he wasn't, I think, in a position to make a factual finding in relation to that, but he'd made what I might call a finding of structure in paragraph 3. I think my lordship referred me to 370. So I think he's just referring to the contractual structure there and nothing more. But he did say clearly that the contractual structure they signed up to would give them the right to nothing more than a salary, unless there were dividends paid out of FCM, and that's clearly part of his judgment.
Yes.
Now, I've introduced to you paragraphs 368 to 372 and 376, And that brings me on to another footnote point, but an important one, because one of the written allegations, I don't think it featured in oral advocacy, but one of the written points made by the learned friend Miss Skeleton is that the judge had not addressed the defendants individually. And it seems to me he plainly has. In 376 shows that he has carried out that exercise. So, my Lord, we would respectfully say, if we work through this, that in 372 there is a clear, unequivocal finding that they knew that Mr. Taby did not have authority. So, as a matter of law, he had no authority. And they knew he had no authority.
And can we... this was the point I was waiting for, because this is the point at which we're going to look, I hope, at the 4 paragraphs that led to this reasoning, this conclusion. As I noted it down and reread overnight, this conclusion at 372 is reached, you say, by going back to, first of all, to 342, where the judge says that Mr. Mutaz Atabi knew that the payment was a termination fee due to the fund, and that he gave his informed consent to its diversion. Given his position with the fund and FIML, it was not open to him to agree to a diversion away from the fund to the benefit of himself or others of a payment that was being made and to which the fund was entitled. He was not acting with the authority of the fund's board. You then go back to 338, which is where the judge says, I'm able to make the finding 610 in relation to the termination fee, including what the fund describes as the diverted sum in this way. Mr. Churchill, Mr. Diallo and Mr. Nuseibeh could not reasonably have interpreted any act by the fund as giving Mr. Mutaz Atabi authority to agree to the fund not receiving the termination fee that was to be paid, and to someone else receiving it instead, in circumstances where Mr. Churchill, Mr. Diallo and Mr. Nuseibeh knew that the right to the termination fee was the fund's. And then you go back to 333 to find this, what the legal finding 610 is, which is the basis for all this. Mr. Churchill, Mr. Diallo and Mr. Nuseibeh could not reasonably have interpreted any act by the fund as giving Mr. Mutaz authority to agree to the fund not receiving the payments in circumstances where they had at least constructive knowledge of the break fee clause and the NAV assessment requirement in the offering memorandum, and therefore ought to have known that any decision involving the fund breaching its contractual obligations to its investor shareholders. Now, am I wrong? I mean, those are the 4 paragraphs that you referred us to yesterday as leading to the conclusion that you now place reliance on in 372, to which I hope you're going to address at some point on what basis it's appropriate for the judge to rely upon a finding of, quotes, at least constructive knowledge of 2 provisions in the offering memorandum as the foundation for then knowledge that Mutaz Atabi had no authority on behalf of the fund to agree the treatment of the 2.2 million. Because that seems to be the foundation of the judge's...
Well, I think we can... I did take you to those paragraphs yesterday, but I think one can look...
Well, yeah, you did. You see, well, actually, what you did was you, as it were, said this was the 4, and I think we do we not need to unpick, or at least to understand, on what basis something which is said to be at least constructive knowledge of 2 provisions in the offering memorandum is said to be the basis for the conclusion that Mutaz Atabi had no authority.
I also took your lordship to paragraphs 135 and 136. Page 143.
Okay.
Where in respect of finding 6.7, all 3 of them were aware of the NAV assessment requirement.
And indeed, and I said to you, where is the NAV assessment requirement, and you were going to take me to it. And what you took me to this morning was simply a clause that said the scheme or the funds administrators will assess NAV on a quarterly basis. It doesn't say anything else other than that.
Can I just, I still haven't, I'll have to see what I can find over the shorter journey, but it doesn't seem to be, if I may say so, to matter whether, what the fund has to do is to undertake a quarterly assessment of its assets.
Yes.
They knew that.
Yes.
So they knew that it was the fund's job, and only the fund's job, to decide from time to time what was available to be paid to the preference shareholders, the investors, and what was available to be retained or what needed to be retained against other expenses, and what could again be paid to FIML.
Did the other investors get a 5% flat return?
Well, I think I think it might have been different. Some of them were lower at 4%, and I think it's up to 5%. So there's still an assessment to be made
On their investment?
on that. There's still an investment.
What's NAV got to do with that?
There's still assessments to be made on whether money needs to be retained in the fund for example, if they would know, I'm sorry, but I interrupt your lordship, but let me stop. Let me leave a gap. They would still have to make an assessment of what, if anything, to retain in the fund against a rainy day. It's an investment fund with coupons to pay. It will therefore be their decision to decide, having made those two earlier decisions, what to pay to FIML. Now, FIML had a contractual obligation to certain sums of money, but it wasn't absolute because it was dependent upon what the board, the decisions the board made. Now, the knowledge of the individual defendants that was a board decision of the fund must be beyond question. So when I said earlier, yesterday, it's not for servants of the fund to decide in advance of the fund making its own decision that the fund will make a certain distribution. It's for the fund to make that decision. They knew they were bypassing that. So when we're looking here at the conclusion the judge draws as to whether Mr. Otabi had authority to bypass that, there was no material for them to have that view. There was a board of directors. Now, the defendants tried to say in their evidence that Mr. Whitworth didn't do much and Mr. LeBeau was a Maples administrator. It's entirely open to the judge to conclude that that's not a fair representation of the way in which the board worked. And all he's saying here is they appreciated that his authority did not extend to allow him to treat assets of the fund as his own, to apply to his advantage, or give away for his own purposes. Now, we've talked about the width of that language, but that can't be the judge asking himself the question whether Mr. Otabi could steal the money for somebody else or do. He was talking about it only in circumstances of this case.
Sorry, 333, which is a critical paragraph, appears to be the foundation for the judge's ultimate conclusion that the three defendants at 372 appreciated that Mr. Otabi did not have authority, sorry, appreciated that the fund had not agreed to the treatment of the 2.2 million. Because I don't otherwise understand, well, unless you can tell me what it is. Mr. Churchill, it's a critical finding. Mr. Churchill, for purposes of dishonesty, it's the first stage. What did they know or believe? They appreciated that the fund had not agreed to the treatment of the 2.2 million. And the foundation, I thought you told presented, the foundation for that finding was to be found in 342, 333 and 338. And what I'm putting to you, I'm asking for an explanation, is legal finding 6.10 is in fact, it's not a finding of actual knowledge at all. It's a finding that because the three individuals had, quote, at least constructive knowledge of two provisions in the offering memorandum, that they ought to have known that any such decision, i.e. any act of the fund giving Mutaz authority to agree to the fund not receiving the payments, involved the fund breaching its contractual obligations. I mean, I understand, what's if they actually knew that Mr. Mutabi had no authority, that's one thing, but that's not what the judge finds in 333.
In 333,
He finds at best that they ought to have known by a process of constructive knowledge of two provisions in the offering memorandum, one of which I haven't yet seen, I think, the NAV assessment requirement, because all I've been given is simply reference to a clause that says quarterly the administrators will perform a NAV assessment. And the break fee clause is one which I think you referred us to, but the judge also found didn't prevent money being paid out for all time.
yes, that's the paragraph, the sentence we looked at this morning.
At some point, you're going to have to, please, at least for me, I speak entirely for myself, not for anybody else, but those were the 4 paragraphs you took us through, and you've got to make good that you can found a finding of dishonesty on the basis of that type of material.
Don't answer now, Mr. Jones. Answer at 2 o'clock.
All rise.